Okay, so this is a very short guide to court reporting for the NCTJ Diploma in Multimedia Journalism. Cases start at a magistrates or equivalent youth court for under 18s, where 94% of cases will be resolved. Magistrates are members of the public who receive 18 days of legal training and have limited sentencing powers up to 6 months per offence, capped at 12 months for consecutive sentences. Magistrates can deal with simple charges like drunkenness, also known as summary trials, and some either way offences like handling stolen goods, which can either be dealt with at magistrates or at Crown Court, especially if the accused here decides that they would prefer to be trialled by jury, which could be a good idea for them, as magistrates are statistically more likely to prosecute than a 12-person Crown Court jury. There are also indictable only cases which will be quickly turned around and handed up to Crown Courts with harsher sentencing powers for more serious cases. So firstly, we'll look at the appeal process. If you are sentenced by a magistrate and don't like the decision, then you can appeal it at a Crown Court. If that doesn't work, you can appeal again to go to the Court of Appeal, which may be worth your time. You are now 10 times as likely to have your sentence reduced as you are to have it increased when appealing at the COA. Appeals thereafter go up to the Supreme Court, and an appeal on a point of law would go to the Queen's Bench Division at the High Court. So the process is very similar for civil law, escalating to County Court, then to High Court, then to the Court of Appeal, and then to the Supreme Court. So if you plead guilty in the first instance, the judge will hear a summary of the case facts, consider any victim statements, which is called an impact statement, and then any mitigation by the defendant. Rather than investigating this any further, the court will bank an easy win and proceed to sentencing. From here, it's go straight to sentencing. Do not pass go. Do not collect 200. Job done. There are 6 regions of England and Wales called circuits, and circuit judges have spent the last 850 years servicing them. So out of the reformation of common law, this is the Assize of Clarendon, 1166, to supplant arbitrary local rulings, a cadre of circuit judges was established to roam the circuits and apply these new rules. So as well as these regular Crown Court judges, there are also part-time recorded judges who do more or less the same thing but for a fee rather than a salary, and they can work on county courts as well. There are also district judges who work on county courts and magistrate courts, which is easily remembered by the district county terminology. Okay, so we'll work through a quick criminal case and see how things run. This is Johnny. He's enjoying himself at a party when Sam comes over and starts mouthing off. The two end up in a fight. Johnny doesn't know his own strength. He hits Sam and breaks his jaw. So Johnny is swiftly arrested by the police, and the CPS, Crown Prosecution Service, will gather together enough of a case to charge him for grievous bodily harm. If Johnny's household income is under £37,500, he can benefit from legal aid, which is something reporters will later be able to cite in their write-up. He'll receive a solicitor to rush around speaking to witnesses and gathering evidence to build a case. Solicitor can't represent their client directly, but they may have the right of audience to speak on their behalf. Usually Johnny will be represented by a barrister with 10 plus years of experience in court. So in adversarial proceedings, as in the UK, the prosecution and the defence will both make a narrative case for Johnny's guilt or innocence of the crime, and in front of a Crown Court jury, again of 12, they'll be trying to prove that he is or is not guilty beyond reasonable doubt. Had this been a civil court, the balance of probabilities would have been enough to determine guilt or innocence. Although juries are seldom used in civil courts these days outside of fraud, malicious prosecution and false imprisonment. So at the initial arraignment stage, Johnny pleads guilty or not guilty to each charge on the indictment. As Johnny has here decided to plead not guilty, he'll be tried first at the magistrates' court, opening with a summary trial, regardless of the offence. It's not just summary offences, and there will be no jury. So with a more serious either way or indictable only case like this, serious enough to go on to Crown Court, the case will be subject to reporting restrictions under Section 52A of the Crime and Disorder Act 1998. This is really the main one. So the 8 things that you can report on outside of like the basic details of it was a cloudy winter day in November, is these 8 things. So as Johnny is innocent until proven guilty, as a broad rule of thumb, reporters should avoid covering anything that the prosecution says, as it may later prejudice a jury by implying his guilt. The prosecution makes a speech and witness testify under oath to demonstrate it's worth going to full trial. At this point, the defence can submit that there is no case, evidence insufficient, and that magistrates either will agree with the defence and dismiss the case, or agree with the prosecution and proceed. So quickly it goes the other way. Defence witnesses are then called and questioned, perhaps cross-examined by the prosecution and re-examined by the defence. The defence issues the closing speech, and the defendant is acquitted or sentenced. Or sentencing can be adjourned for a later date, just in case your time isn't important enough. If the case is serious and goes to Crown Courts, then a pre-trial hearing is for the judge to establish reporting restrictions, bail conditions, and what the jury will be told before full trial. Under the Bail Act 1976, bail should ordinarily be given unless it's expected that the defendant will abscond or commit another crime. Failing that, they can be held in remand for about 6 months, which under a stress legal system is becoming ever more common. The preparatory trial also takes place before a full Crown Court hearing and serves to prepare for long and complex cases before the jury is sworn in. Okay, so defamation. Let's say you are reporting on this case and a witness comes forward and says something defamatory about Johnny. If you're reporting fairly, i.e. hearing both sides, not skimming the story, and are not in breach of any reporting restrictions, if you're reporting accurately and you're reporting contemporaneously, as soon as practicable, then you and the witness are protected by absolute privilege. Reporting after the event, e.g. by stealing somebody else's story, is also protected by privilege, qualified privilege here, so long as your report is fair, accurate, published without malice, and on matters of public concern. So documents in court will usually be read aloud, but those that are not protected by QP Part 2, those that are read aloud, those that are not read aloud will be protected by qualified privilege Part 2, which basically just requires you to give Johnny space to explain or contradict the allegation. But as almost all documents will be read aloud, under Part 1 you wouldn't be expected to give this. So wrapping up, the Defamation Act 2013 sets out your main defences if privilege failed. Firstly, that the defamatory statement was substantially true. It is a defence under Section 2 of the Act, that you can demonstrate that what was being said was fair game, or that it was an honestly held opinion by the person you're quoting, that it was recognisable as such based on something true, indicative of what it was based on. This is Section 3. There's also Section 4, which will protect you when reporting on things on a matter of public interest. So that is going to be the first half of court reporting, and we'll come back to anonymity, open justice and coroner's courts for the second one.